behind and trigger this mandated hearing, that alone provides the state a glimpse into our trial strategy, which is protected and privileged and ought to be, in the same way that we would expect that, frankly, in a civil matter where these types of issues are under consideration. In addition, there's a due process concern here as well. There's no precedent. Let me back up and say, when you look from line 23, it points you to page 3, which is 177130 B1A. And this makes clear that not only is this hearing mandated, shall hold a hearing, but that the prosecuting attorney may submit information regarding the accused's current mental competency to stand trial. It does, thankfully, provide the opportunity for defense counsel to ask for ex parte consideration of the evidence that they would present, and to seal that evidence later, which we are definitely fans of those aspects of this. But the mandated trial and the injection of the state into this process are concerning to us. There is no precedent for allowing the state to participate in a gatekeeping function of this sort that is meant to be under the court's purview. It violates the notions of fundamental fairness to the accused, quite frankly. As the conversations have flowed from this bill and the policies that it represents, some of the concerns that have been mentioned are that judges are concerned about what to do. Well, we shouldn't make accommodations on the backs of the most vulnerable people facing criminal prosecution when we could educate judges on matters of not only basic ideas around competency, but their ability to issue these orders for evaluation. And like I've mentioned, the expense here is of constitutional proportion. Making accommodations for prosecutors based on their assertion that more often than not, they are in a better position to assist the court with competency determinations than psychological professionals that are trained in such assessments is also a concern to us. Concerns about frivolous competency queries, as I've mentioned, can be cured short of mandated hearings that violate a person's constitutional rights. And the idea that the hearing would be predicated on that person's attorney's actions, the idea that a step we would take in defense of our clients would then jeopardize them in this way, it will chill our ability to effectively serve and represent zealously and provide adequate counsel to these clients in this position. We know there's a backlog. We do not like having our clients languish in these jails. You all are among the people in this building probably most privy to some of the horrific reports that have come out of jail, specifically one jail in our state that's not very far away. I do not want my clients, especially those who are incompetent, languishing in a place like that. It's torturous. We are not trying to bog down the process just to bog it down. Rather than address the lack of resources within DBHDD to accommodate the task of executing professionally, psychologically, evidence-based competency evaluations and shifting that, because now the resources are going to be spent under this bill with these mandated hearings. The courts are going to be spending resources, the public defenders are going to be spending resources, private citizens who have their own counsel, and prosecutors attending to these hearings. You're shifting where the money's being spent. Instead of spending it at DBHDD to increase their resources to address this issue, you're just shifting it. And you're shifting it in a way that's going to potentially violate many people's constitutional rights. It seems like this bill is aimed to have DBHDD assist with as few competency evaluations as possible. And that seems wrong and unjust. And we would ask that you return to the language that the subcommittee adopted just last week that is not showing up in the bill that you're reviewing today.
Thank you. One question.
Yes, sir.
And I think I'm begging this question more and more to weed all out this progressive positivism in the law thought that seems to be pervading in this state right now and through certain bills, not saying here. How long has this current process been in place in this state?
I do not know, sir.
Okay. If y'all can find out and let me know, I'm very big on that.
You mean the process that's codified in 17.7, 129, 30?
As
Sure.
it currently exists,
Okay.
the current process for mental evaluations.
Okay.
Number 13, I think that's Chairman Leverett. Good to see you back in Judy Non-Civil.
So good to be back at the Fistulate Club, Mr. Chairman. Good to be here with you. Glad to be back. I hope this hearing doesn't go as long as some of the ones I've presided over recently. Thank you for your testimony. I always appreciate your input. I'm trying to understand the process. So if you, as defense counsel, you would have a duty to your client to if you believe there's a competency issue, to run down that rabbit hole, wouldn't you, and determine whether or not the person is incompetent to stand trial? Because if they are incompetent, that stops everything, doesn't it?
It does, until there could potentially be a restoration of competency, which is also something that DBHDD specializes in and has the tools and resources, well, probably not enough resources, but they do have in theory, the ability to do that. But it's also important, I'm glad you mentioned this, it's not only a duty to my client, but we have duties of professional conduct and candor to the court.
Yeah.
I mean, in a way, the mandated hearing in this concept that you're considering today really puts defense lawyers in a bind with respect to our duty to the court, our duty to our clients, our duty to opposing counsel. I know lawyers get a bad name, even down here sometimes, but there are professional standards that we are held to and ought to be held to, and I find it difficult to be able to figure out exactly how to thread all of those properly in a mandated hearing situation laid out in this bill.
Okay, so help me understand this, because
Yes.
as you know, as I've often said, I don't know a lot of criminal work. So the concern you have is not the requirement, because there's really not a requirement of disclosure, there's a requirement of a hearing if you disclose. Are you concerned that there ought to be a way for you to disclose a concern to the court without it resulting in a hearing where everything's got to come out before the prosecution?
Yes, which is what happens often today. I mean, you can see from even in the bill, if you can see that right now at line 44, if we file a motion requesting an evaluation, the court may order the evaluation, et cetera, et cetera. That process on page 3 at line 44 is what happens if we file an actual motion. But if you back up to page 2.
Let me stop here for a second.
Sorry, okay.
So 44 is shall. If an accused file a motion, then the court has to hold the hearing. And back over here in section 1, if information is made known, the court shall. The hearing's required also.
Well,
correct?
I'm sorry, sir, but I just meant today, the current law that you see there, if you file a motion,
I see.
you may, the court, it's discretionary today regarding the issuance of the order for the evaluation. It doesn't even, today there's not a hearing requirement.
I see. The court may order.
But we do expect, I will just in candor, I mean, in all transparency say, if we file an actual motion, we actually expect a hearing. I mean, there's not a mandate here, but that's typically what happens when you file a motion, right? The adversarial party gets a chance to challenge it.
Mm-hmm.
But if you go back to page 2, back up at line 19, this idea, and this is, I'm talking about current law, so ignoring the additions in 21 to 24, right? Or, I'm sorry, I might be on, I know it's still 21 to 24. And again, I'm hearkening back to my experience. Even when I was doing death penalty defense work, it was rare that I would file an actual pleading to ask for this evaluation. It was typically, and is typically, an ex parte conversation with the court, explaining through what's arguably very privileged experiences and information why I believe the court ought to issue an order for an evaluation. So it's not an adversarial process typically. What we know practically is a lot of circuits do end up having some kind of a competency docket, so that if I were to ask the court ex parte for an evaluation, the chances are the state's going to know I asked for that because it's going to show up somehow. The person's going to leave the jail if the order is issued. There's lots of practical ways the state can become aware that it's happening. But they don't become aware of the basis. They don't become aware of whether or not I've already had an evaluation done that the court wants me to challenge, because then that's another potential line of defense for us, maybe. I mean, so right now, there's not typically an adversarial process in order to access the evaluation, which I know is part of what the prosecutors would like to have, and I understand why we're here, and that's their desire, is to be a part of that process. We are not. We tried to offer a way to allow both, so that if the court has a bona fide concern, we don't need to really have a hearing. But if there's insufficient basis to raise a bona fide concern, then the court could have a hearing and allow the state to participate. I mean, so that's where, when we left subcommittee last week, that's where I believe we had all landed. And I don't want to speak for the chairman, but the language that was discussed that day included that opportunity if the court was questioning the had bona fide doubt.
So is the one final question, Mr. Chairman. So is the tension here the fact that, I'm assuming as a prosecutor, I would like to know this too, because on the one hand, it stops my prosecution, which I may not like, but on the other hand, I would assume that's a potential appeal issue if there are facts or circumstances disclosed and it turns out somebody was not competent and they were forced to sit through a trial.
Sure, I think the fact of the evaluation happening is of less concern to us than this mandated hearing process.
Okay.
Right. I mean, there's a lot of stuff that they do in their investigations I'd like to know beforehand too. Mm-hmm. And there's plenty of, that unreasonable release of information from both sides is not the way any of us want to play.
Yeah.
But.
Okay. All right. Thank you. Thank you, Mr. Chairman.
Number 6, Representative Neal.
Thank you to the chair. So I guess my question would be, the draft that we just switched right before we started, LC 481593S, is that the clean version that came out of subcommittee before?
No, ma'am. I haven't actually seen a version that incorporates what I personally that I thought we left subcommittee having agreed to. But I also know that there can be work that happens after that fact, that
Okay.
Chairman wasn't required to bring that version here today. I haven't seen the version that would have reflected, because we came to the subcommittee and didn't talk substantively about the bill because we believed we were all in agreement to the language. So this is the first time I'm actually addressing the substance because I thought we had come to consensus.
So it's not this version that we're doing now. It's not the one we just replaced.
No,
is there another version? It's just discussion.
I have no idea if there was an LC produced or not.
Okay, gotcha. Okay, thank you.
Ladies and Lynn, I have a question.
Yes, sir.
So, even with the changes made in the subcommittee, I mean, what if a judge just decides they're in favor of speeding the whole thing up and speed is their concern? Mm-hmm. I hope speed wouldn't be the only concern of a judge. I'm thankful to have a great constituent who just happens to be one of my Superior Court judges here today.
And a former member of this body.
A former member, Chief Deputy Whip. Good to have you again, Judge Hightower. Thank you. He's a great example of one of those that doesn't prefer speed, prefers justice to be done. But my question is, even with those changes in the subcommittee substitute, I mean, if I got a judge that's worried about speed, I mean, we could be forced to turn over privileged information.
Well, I guess I would disagree to the extent that what came out of subcommittee was permissive.
Okay.
It didn't require the hearing. So a judge who wants to speed things up could just say no to the evaluation, and I'm not sure what would happen if the defense lawyer then still filed a special plea of incompetency. That would still have to be pursued, but that is, unless requested by one of the parties, to look at the language, it's a bench trial unless it's requested by one of the parties. So the judge, in your hypothesis, I would say it would be faster with what came out of subcommittee because the hearing becomes permissive. the bills that have been discussed, the versions that have been discussed today, mandate hearings. So anytime you're going to inject a mandated hearing into, I mean, any sort of proceeding, you're adding hearings to the docket. You're not making anything faster.
Okay. Here's what I'm going to do. Chairman Strickland, I hope you'll indulge me. We have competing substitutes here, and just so I'll be satisfied personally on this, I'd like for parties to get together and merge these before we have any more testimony. I value the work of our subcommittees very much so, and you know, if I want to just have another substitute, I appreciate the work, and I hope the changes will get us in a good position where we can make some progress on this. What I'm going to do is I'm going to suspend any more testimony on this. I'm going to have the parties work offline. We'll come back to this bill. I'm not going to negate the hard work of my subcommittees and the great members that we had on there. So, Chairman Strickland, you want to present the next bill?
Yes, sir. All right. I have this recurring fear. I don't think I've done this yet in my career, but that I'll come in front of somebody and present the wrong bill, and then y'all will actually pass the wrong bill. But I think that's the worst part of the fear. I think one time we did that in the Senate. I won't say who did it. Now we're looking at Senate Bill 207, and we are working off of LC 492185. Is that what you have, Mr. Chairman? And the good news on this one, this is the version that not only came out of subcommittee, but also passed the Senate. You will recognize this bill if you start reading its 95 pages, which I'm sure you all did before you came in today. You'll recognize this as Senate Bill 157 from the last 2 years. Y'all have passed this bill out twice in this committee in the last 2 years. This bill deals with how our occupational licensing boards address criminal records when looking at granting or denying licenses. 1 in 6 jobs in our state require an occupational license. Every board, though, treats records differently. And we've heard over the last 3 years of working on this bill from individuals that have gotten so frustrated with the process because they invest the time and money into training and education for a job, and they're then denied that job from something in their past they didn't realize was going to be an issue. Or you hear from people that don't even spend the time to try to go work and try to get education training because they assume that their past crimes could keep them from getting a job. And of all of our work on criminal justice reform, of course, under Governor Deal and what we continued since that time, one thing that we know that is most likely to get someone out of our criminal justice system is having a purpose and having a reason to get up every day. And for a lot of people, that's a job, a way to support their family, a way to say no when they're encouraged to go on the streets and get involved in criminal activity because they have something else to work for. So this bill comes with a lot of support. Backing up, I didn't say this in subcommittee, just the history. This bill comes from a working group that was started after Governor Deal left office of several groups and several senators and representatives that said, what else can we do to continue the work on being smarter about how we approach criminal justice? And this is maybe the 3rd or 4th bill from that unofficial group that didn't have a name to it. But it comes with the support of the Georgia Justice Project, Metro Chamber, Georgia Chamber, Faith and Freedom Coalition, and many, many others that have all gotten behind this bill because it's the right thing to do for people in our state. It's the right way to be smarter about how we deal with crime in our state, and it's the right thing for our businesses in our state. So I'll keep it higher level since you've heard it a few times, and happy to dive in deeper if you want. But the bill, first off, requires there be this nexus between the crimes you committed in the past and the job you want to work in. And the bill establishes that there must be a direct relationship found between the criminal record and the licensed occupation, and that the licensure would pose a direct and substantial risk to public safety because the applicant has not been rehabilitated to safely perform the license duties and responsibilities. In other words, if I have a DUI from 10 years ago, should that keep me from being a plumber? But if I have a theft that I've committed, should I then go work in a long-term care facility? There's a nexus in the latter that you might not have in the first, obviously. Second, knowing there's now this finding that the boards have to make if they're going to deny a license, there's an appeal process built in through Administrative Procedures Act, where there's certain standards of proof, written findings that are made, and we have a whole process set up where someone can now appeal if their license is denied. Third, there's a predetermination process now built in. We're going back to where I started. If someone thinks, okay, I don't know how this record may impact me, they can go and get a predetermination through a board before they spend time and money training to see whether or not their past crimes will keep them from getting a license. There's also a requirement that every board will post on their websites this new procedure we're going to have with this code, so everyone can see how this process will work and know how their criminal records will be used. And finally, it's going to require certain public data to be published to us, where we will now, the public, I say us, the public will now see how criminal records are impacting those that want to go work, which is good for all of us, I think. And Mr. Chairman, there's certain cleanup, and I know Wade Askew is here from Georgia Justice Project. There's some cleanup stuff on record restriction laws that was put into the bill last year by this committee, or maybe it was 2 years ago, but y'all voted on before as well. The only changes from this bill and what you voted on last year, and you actually passed this very late in session. I think it was House Bill 808 or Senate Bill 808. I can't remember the number now, but it was 8 something. I remember that. It was so late that we were not able to get it passed on the Senate side to get it to become law. There's a couple of tweaks you'll see at the very end of this. There's some cleanup, not substantive stuff, dealing with our licensing, restrictions on licensing, dealing with record restrictions as well. With that, Mr. Chairman, happy to answer any questions.
I had a hypothetical for you, Mr. Chairman.
All right.
You talked about the nexus and the job you want to work in. So we used to have old drunk that would go get up by the time the dew had got off the hay field to come and help us cut hay. Best hay hand that we ever had. Let's say that he stole beer out of the cooler, and he'd kept on doing this, and so finally we just had charges pressed against him for stealing beer. All right, he gets convicted and stealing that beer out of that cooler. Well, he comes back and wants to work with another hay cutting outfit. Would the nexus connection there apply as the scenario I just outlined?
Depends on how much that second outfit appreciates their beer.
That's all I have on that one. Any questions?
It was almost like we planned that. I thought you were throwing me a softball.
I didn't know you needed a license.
Any questions from members of the committee? All right. Okay. Number 6, Representative Neal.
Do you still feel a way about your beer being stolen?
In that situation, the chair would probably just include beer as compensation package.
That'd be the compromise.
Oh, all right. Seeing no other questions, if you want to just slide over.
Thank you.
I was just here for questions.
We love your discretion there, Mr. Askew. Anyone else signed up on 207? Pat, Robert, Pete, everybody good? All right, number 13, Chairman Leverett.
I was just ready to make a motion when you are, Mr.
I'll
Chairman.
take it.
Move to pass.
Oh, we don't have quorum, so hold that. All right, need one more. We'll wait for Representative Gullett to come back. All right.
9.
So,
It's 9, isn't it 8?
let's see. I'm going to go on to Senate Bill 74, Congressman Emeritus. Upped his reputation by coming down here to the State House.
Ooh, that's a low chair, Mr. Chairman. Thank you, Mr. Chairman and committee. I appreciate an opportunity to present Senate Bill 74. I'm working off of LC 492294S. Is that what you got? Thank you. Let me quickly review the bill. It's a straightforward bill, but I want you to understand a few things. Let's talk about what it doesn't do. The bill does not change the current Georgia obscenity law, which is OCGA 16-12-103. It does not ban any book or any library material. It does not limit any access to any book or library material for adults. And so the question is, what does the bill do? Well, it requires all Georgians to follow Georgia law. It protects children from harmful materials, and it provides an affirmative defense for librarians and library staff. So let's look at the bill. First, section 1 on lines 15 and 18. This is what is commonly referred to as the exceptions clause, which would not apply. Currently, the law, section 16-12-103, does not apply to any public library operated by the state. This would strike that clause and replace it with reserve. So it strikes the exception clause of Georgia obscenity law. And then if you look further at section 2, let me back up a second. Let's make sure we understand that 16-12-103 is long established Georgia law. It was adopted in the late 60s. It was modified and updated in the early 80s. We have over 50 years of experience in this particular code section. In 1984, section 16-12-104, the exceptions clause was added, and I'm still unclear as to why we chose to add that. At the end of the day, every Georgian, other than librarians, must comply with 16-12-103. So every 6th grade teacher, every middle school coach, every pastor, every store clerk, every member of this committee, every Georgian must comply with 16-12-103. So, ironically, the professionals who are most qualified to determine what might be harmful to minors are exempt. And so Senate Bill 74 simply removes that exception. It's not punitive. It's not intended to criminalize anyone. It's designed to protect children. Let's look at section 2. Section 2, line 22. Notice the word knowingly. Except as provided in this subsection, any person who knowingly violates the provision of 16-12-103 will be guilty of a misdemeanor of a high and aggravated nature. We inserted the word knowingly. So that means that the individual must intentionally provide harmful material to minors to be subject to this penalty. And then we added subparagraph C in lines 25 through 29. It's the affirmative defense, so that if a librarian or library workers, notice we expanded it to include anyone who works in the library, if an individual can demonstrate on lines 28 that he or she has made a good faith attempt to identify and remove from access to minors all physical or electronically harmful material, that's their affirmative defense. At the end of the day, I worked in higher education for 30 years. I spent countless hours with my librarians. They are tremendous professionals who do a great job. And what we'd like to ask them to do is to comply with the same code that every other Georgian complies with. Again, not punitive, not designed to penalize. It's designed to protect children. Currently, 12 states have removed the exemption clause totally. The majority of the states are moving in the direction that this bill moves into, which provides for an affirmative defense. Only 4 states currently have the clause in its current form in Georgia. Georgia is one of those 4 states. So I'm happy to take questions, but I urge you to support Senate Bill 74.
Thank you, Mr. Chairman. Y'all got a golf tournament coming up?
We do. We'd love to have you come down. You know, it's a little bit far from the other side of the state, but we welcome West Georgians to Augusta.
Straight shot on 20.
Absolutely.
Number 7, Representative Roberts.
Thank you, Mr. Chair. Bear with me just one second. So, of course, I'm not in favor of harmful materials being given to minors, but I guess my question is, how would a librarian be expected to surveil the electronic material on computers in the library?
That's already being done.
Tell me how.
Well, there are any number of software tools that are used in both libraries and public schools and universities. So materials are classified and then appropriately cataloged. So this is really a cataloging requirement. And again, from the electronic perspective, if I go to, let's say, the University of Georgia, and I get on the University of Georgia's website, there are certain websites I'm not allowed to access because they might contain pornographic material. We already have those opportunities in place. This is primarily directed at books that are shelved in our libraries that are designated for children and youth. And what we're asking is that those books be reshelved into adult sections so that they're not readily available to minors. If a parent accompanying a child goes to a library, that parent has access to all material. And that parent has the responsibility for providing whatever material they feel appropriate for their child. So this is not targeted at the electronic systems, but the electronic systems are already in place.
Can you break down I understand what you're saying, that that we're doing this in schools, but in a library, I assume the computers are for everybody.
They are, but they also have the same software filters that are associated with schools and all public libraries. So if you're in a public place, and I suggest that you take your phone and Google whatever website you might choose and see if it's filtered in the Georgia state system. Be careful. You might find something that would offend you.
No,
I'm just saying.
I'll leave that one alone. I guess I'm just, I feel like we have criminalized so many different industries and professionals in this body. We've criminalized doctors. We've criminalized jailers. We've criminalized. Now we're talking about libraries. I mean,
have we criminalized state representatives?
If they commit a crime that's on the books.
Exactly. So if
you're creating a crime. You are creating a crime for librarians. Yes, you are.
The crime has already been in place for over 50 years, Representative Roberts.
But this is a different environment, and these people are trained.
My position with librarians, and let me give you a little more background. Being in the university system for 30 years, I work with librarians constantly. They're wonderful professionals that do a tremendous service, and I'm grateful for that. 2 decades ago, I had the privilege of being in Sweden on a senior Fulbright fellowship at the Swedish School of Library and Information Science. So I've worked in these environments. I have seen the good work that they do. Mm-hmm. The overwhelming majority of librarians already comply with this code section, 1612-103.
Then why do we need it?
Because the exception exists for no reasonable purpose. We're removing the exception.
Well, I love to talk about things that I think are constitutional or unconstitutional, because we've had lots of those conversations in other committees, and so I question whether or not this one's going to pass muster.
Well, let me suggest that the states, there's one state out there that has adopted some litigation that's been blocked by the courts. Indiana, currently law. Missouri, currently law. Oklahoma, currently law. Tennessee, currently law. And these are all states like Georgia. By the way, they're blue states and red states and green states and purple states. So this is not a political issue. This is an issue designed.
And they all make it a crime.
It is much more severe than Georgia's. In Indiana, it's $10,000 in 2.5 years. In Missouri, it's $2,000 and jail for a year. In Oklahoma, it's $20,000 and 10 years in prison. So Georgia is just coming into line with removing the exception and providing for an affirmative defense.
I'll let somebody else go.
I want to play musical chairs real quick.
Pass that over to
We're going to go back to Senate Bill 42.
Musical chairs.
Senator Hatchett. Any discussion by members I'll come back to y'all. Y'all just light back up. Y'all have a question on 42? Okay, all right. Any questions on 42 before? All right, got to move. Second. All those in favor of the passage of Senate Bill 42, say aye. All those opposed, same sign. Thank you. Who's going to be carrying this?
Leader Hong.
Okay, good deal. Tell the First Lady we sure do appreciate her continued work on these matters.
Thank you, Mr. Chairman.
And yours as well.
Appreciate you.
Yep.
Thank you.
All right, next I'm going to go back to Senate Bill 207, Chairman Strickland. You can say anything or not. I'll give you the
No
floor.
comment. Thank you.
Okay, all right. Any discussion from members of the committee? Are y'all lighting up for this one, or? All right, I got a motion to do pass. Second. Any amendments here? None. All those in favor say aye. Those opposed, same sign. Congratulations, you're on the rules. I'm carrying this one for you, Chairman.
Okay.
All
Yes,
right.
sir. Thank you. I
Sound
appreciate
good.
it. Thank you all.
Thank you. We'll get rules forms for y'all real quick. I'll sign those and y'all can take them on up to Chairman Parrish.
Okay. Thank you.
May
I'll
the-
back on the other one.
May the odds be in your favor. All right. We're back on to Senate Bill 74 with Chairman Burns. Number 5, Representative Holly, the freshman on the committee.
Welcome. Thank you. I was about to. Every day I grow gray hairs, but with that comment, I think one retracted. So
That's
thank
right.
you. So I appreciate the concerns when it comes to our public libraries. For me, 7 years into this role, and I've always made it very clear that for working class persons like my family, my mother, she would take us to the libraries as kids, we give us book reports and extra things on top of classroom assignments. Libraries have kind of grown me. So, as well as I've taken a liking to the administration of the libraries. Also, I've written arrest warrants in a building that's 2 blocks from here, and for felonies, but also on misdemeanors of a high and aggravated nature.
Right.
Which is, to my surprise, when I looked and saw that from line 24, that this would be, if a prosecution was successful, that it would be considered a misdemeanor of high and aggravated nature. I wanted to know from you, since you are the bill's author,
Sure.
what misdemeanors are you currently aware of upon which this charge you would find to be at least complimentary?
Okay. The Washington Post, in an article on April the 16th of 2024, like to quote from their article, if I can find the right page. And I quote, "The Post could not find an instance in which a librarian has been charged under these laws." This is not Georgia laws. This is laws similar to this across the U.S. So not a single instance. And so the question is why? Well, it's very simple. Librarians are doing a good job. And there's no reason to include an exception to a classification of individuals. You, sir, are not exempted. I am not exempted.
Right.
And a store clerk, if I'm a store clerk at Barnes and Nobles, and I make harmful material available to minors, I am held accountable.
I don't think that answers my question,
All right,
so
let's go
I'm going
again.
to
Hit it
I'll
again.
simplify it a little more. In the Georgia code, because
Right.
our code is very different from this other state, my question was, what misdemeanors that are prosecutable in Georgia that can be charged for crimes that are of a high and aggravated nature that you have seen that are at the level to which this would charge?
I'm not a lawyer, I'm not an attorney or a law enforcement officer, so I'd have to defer.
Yeah.
I would tell you that that is current Georgia law. So we're not changing the law. If you look at 1612-103, if you violate that and then you go to the current code section in lines 22 through 24, which is the prescribed penalties, that the only thing that I have changed is inserted the word knowingly, which adds additional protection to you and to me. So if I knowingly provide harmful material, I'm held responsible. And then we add additional affirmative defense for all library workers. If I might, Mr. Chairman, I'd like to at least share. I've been working over this session with Representative Bethany Soya up in South Dakota, and she provides me some information that helped me understand where we are as a state and how we are not aligned with those that are in our neighboring environment. So if you take a quick glance, you see that most of the United States is in yellow, except for Georgia, Washington, Pennsylvania, Louisiana, and those states still include an exception without any recourse. All of our neighboring states have an affirmative defense with no exception. The states in green have no exception without an affirmative defense. So all I'm saying is we're aligning Georgia with the vast majority of states in the U.S.
The only reason why I ask, and thank you for explaining that, is that while that is a part of the high and aggravated misdemeanor, it's actually a part of the section, but the lines from 16 through 18, that, the provisions for the public library employees, that, like, literally, by deleting that.
Yep.
Right?
It's an exception. You're deleting the exception.
Yeah.
You're removing the exception.
You're removing the exception.
And I agree, and that's the intent of the bill, is to remove the exception.
But, and what I'm saying is that if you're removing the exception, then what you're saying, then what you're also doing is admitting that the provision of this material itself, without regard to the material, because as we know, when it comes to obscenity, not all books are equal.
That's true.
Right?
And not all communities.
Not all communities, but what it's doing as well is, because you're removing the exception, you're now literally putting librarians, the fact that they can be charged for crimes that are very similar to DUI, which is a misdemeanor of high and aggravated nature, right? Battery on a pregnant woman, that's a misdemeanor of a high and aggravated nature. Right?
I agree.
Right. So,
right. Say.
And so, while I think that the intent may be good to at least safeguard for children, quite possibly this measure seems almost puritanical.
How so? I would suggest that a sixth grade teacher is held accountable.
Right. And holding account is good. Like I said,
okay.
holding account.
But all I'm saying is, if they violate, if that sixth grade teacher knowingly provides harmful material, they're held accountable.
Yes.
Under Georgia law.
Or the Georgia law. But look at the specifics of the Georgia law applied. And because when you remove that exception, now it's saying that it's not being charged with a misdemeanor. It's being charged with a misdemeanor of a high aggravated nature. And because of that, that is why that exception was placed in there. It wasn't about holding accountable. The exception is placed in there because of the classification of that misdemeanor. Literally, you're now putting, it's akin to saying, if I know a teacher allows for a student to run around in a classroom with scissors, and we know that people might get hurt with scissors, it's to charge a teacher with something that's that's right up underneath a felony. That's the reason why, and when the law was created, when it put the high and aggravated in there, and remember, as we agree, we just said that not all materials are equal.
True.
Right? The content of itself may not be equal, which means that some things, maybe to a jury, or at least a court of public opinion, might not always be as severe as a book. The reason that exception was included in the law was so that because it's such, the gravity is so heavy that I'm sure the sponsors of the original bill that changed that law probably considered that librarians, those who allow for children to come in, especially with a parent and guardian, they probably are doing so in a manner that is, at least the environment, their culpability in that is not at such a stage to require a charge, if found wrong, of a high and aggravated nature. And I think that's the key part, is that when you remove that exception, it doesn't just hold them accountable, it actually elevates the crime on them to the point of being similar to battery on a pregnant woman.
It's the same penalty that you face. Is that not true? Is it not the same penalty that you would face?
I'm not in the exception. I'm not the.
I know you're not. You're not.
Exception
You're
doesn't
not.
apply
You're
to
not
me.
a part of the exception clause. So and what we're saying is we'd like to put librarians in the exact same classification that you and I are already in. So you and I are currently held accountable at a high and aggravated. And the as far as I can tell, it's tough. As far as I can tell, the exception was put in 1984. I don't know where you were in 1984, but I
was at the library.
That's okay, good. So you were somewhere in the library, which your mother did a great job, and I'm grateful for that. And by the way, my mother took me to the library as well. I grew up in libraries long before the world of the internet. I mean, I had the Britannica, Encyclopedia Britannica,
The world
which was
books.
my primary
Yeah, that was
reference
mine.
point. So at the end of the day, the objective here is to protect children and to make sure that everyone follows Georgia law, without exception. Not to penalize. Let me tell you what I hope will happen. I hope that this legislation will heighten awareness and help protect children. And I would suggest to you that the librarian is the best equipped person to make that decision. And you're right, it will change by material, it will change by location and mores of community, but at the end of the day, the objective is to make sure that harmful material are not readily available to minors.
Yeah, well, I appreciate your passion and sincerity on it. I think if the full intent was to...
Is this a question, Representative?
Oh,
If we won't get into discussion, I'll give you the opportunity.
Okay, I'm sorry. Go right ahead. You're
Sorry.
fine.
Ed Setzler used to do that to me all the time. Rightfully so. Number 13, Chairman Leverett.
Thank you, Mr. Chairman. Good morning.
Good morning.
So, just a couple observations. One, the word knowingly, which you inserted, or the bill would insert into 1612-105, which is basically the penalty section.
It is.
That is a defined term.
That is correct.
In the previous section, so that I think that would give some degree of protection to a potential defendant or librarian who has a large collection, I think. And the affirmative defense, it seems to me, provides some assistance also. I guess in your view, what is this likely to result in as sort of a good best practice for a librarian to avoid a prosecution under this?
I think it's simply a fact that the librarian, if they had questionable material, they would correctly catalog them and shelve them in an adult section and not make them readily available to a minor and not distribute the material to a minor. Don't check it out, except where requested by a parent or a legal guardian.
Do you think then they would also need to restrict access to that particular area so that it would only be by some.
I don't think
permission.
that physical restrictions are necessary. I think that correctly cataloging and shelving the contents in an area that's designated for adults is more than sufficient. It's all we're asking for. We're not carving out a certain area of the library that physically restricts anyone. So you're correct. A child, a minor, under 18, could go into a section that's not designated for them, and they could, in an unsupervised fashion, perhaps still have access to this content, but they couldn't check it out without a parent or a guardian's support.
So one other thought, Mr. Chairman. So in your view, is the violation the allowing the minor to check out, or is it putting the book on the shelf without some special designation or restriction?
I think, and to answer your question, I believe both. I think at the end of the day, a librarian, by the way, a convenience store clerk has to make the same decision. So a convenience store clerk has to decide what material they're going to put out in a publicly accessible area to minors, and they have to restrict material for adults. We're asking the librarian to do the exact same thing. So appropriately identify and catalog and shelve material for adults and not make them readily available to minors, and don't allow a minor to independently check those out.
Well, and I lied, Mr. Chairman. One other question. I did notice, too, in the penalty section, there is a separate provision for a misdemeanor, not a misdemeanor of a high aggravated nature. Did you consider the possibility of making, since we're moving the exemption out completely, of moving to just a misdemeanor penalty for this sort of thing, or did you feel that would be bad?
I would defer to the will of the committee, and happy to consider adjusting that provision if you feel that that's appropriate. I don't think it substantively changes the intent of the bill. So if that's with the will of the committee, I'm comfortable with
I think it would not. I think, by the way, Mr. Chairman, if we need an expert on criminal law, we got one right here. Right. He was telling me about some of the differences between misdemeanor and misdemeanor of a high aggravated nature. You'd still have it be a crime.
Again, we got to recognize that this is current code, and we did not change current code.
Yeah, and I wouldn't want to change that provision right there. And I'm not even necessarily advocating this. I was just trying to get a sense of sponsors.
Why would you not change it for yourself to a misdemeanor? Why would a librarian have a lesser adjudication versus a convenience store clerk or a sixth grade teacher or a coach or a pastor?
I think mainly just the concern about the volume involved. You know, if I'm in a convenience store, I've got just basically a rack of magazines behind me, and it's a little easier to know, I think, on them magazines
I agree.
whether something violates the standard or not.
The pictures might give you a clue.
You know, I've heard stories about those. But when it comes to a literary text,
book, right?
You know, text. I think I don't know that a librarian would read every book they get, and so they might know something about the book. I would assume they would, but again, I'm just throwing that out for conversation. I don't want to change the current penalty for the existing crimes, because if you look through the statute, there's some stuff here that's a little more intentional and direct than simply putting a book on a shelf in a library. But I know that this has been a big concern, certainly in a jurisdiction we share some portions of.
We do.
And I do think in the areas where there has been some resistance to trying to address what I would view to be reasonable concerns, we sometimes have to take these measures. So I just was curious of the sponsor's position on that. So.
I'm happy to defer to the committee if you feel there needs to be a carve out with a lesser violation. That's up to you. At the end of the day, I think it is important that we take every opportunity to protect the children of Georgia. And I would suggest to you that our librarians do a great job, and I support them. I would like to think that they would comply with the same law that you and I comply with.
Thank you. Thank you, Mr.
Thank you. Chairman Gunner.
Thank you, Mr. Chairman. All right. A couple of years ago, I had a situation in Towns County where there was some books on the shelf. They were drawings, colorful drawings that were, I guess, made to entice children to look at the book. I had a county commissioner call and raising cane, what can we do, what can we do? I talked to the folks at the library. They didn't seem to have any concern about making a change. I see your bill as something that can maybe get their attention if that came up. But the high and aggravated would be for, if they continue to do it, I can see high and aggravated, but if they, make a mistake the first time.
The issue is knowingly,
Yeah.
and if you will go to the affirmative defense, they've made a good faith effort.
Well, and in my
Good faith
situation, they knew because they were getting the phone calls from
Okay.
everybody. That
And they responded appropriately. Is that correct?
I can't say that for sure.
Okay. I would hope they would respond
I
appropriately.
would have hoped they did, but as far as I know, they left the book where it was. So, thank you.
Thank you, Mr. Chairman. Okay. Number 6.
Thank you to the chair. So I have a few questions. I'll start with my biggest concern with any law is how it's actually applied. So everything's great on paper here, but when you go outside this building and you ask the law enforcement official, you ask the courts to do something, how does that work? So my first question to you is, who determines knowingly? Who determines intent? And what does that look like?
I would say if someone is accused of violating the statute, you or I, if we were to violate the statute and someone accused us of that, then they would go through the normal proceedings to take out a violation, and then I would have to determine how I would respond. And the issue is the court ultimately is going to determine knowingly, just like they're going to determine good faith efforts.
So what does that burden of proof look like?
I'm not an attorney. I would defer to the attorneys on the panel to kind of help me with that. But realize the objective here is to protect the children and to bring all Georgians in line with longstanding Georgia code.
Yeah, and I understand your overarching
Okay.
goal, but there's a process when it comes to everything, especially the courts.
Okay.
And so that would be my first question for you to ponder over.
Okay.
And then also to, how would you handle mislaid books? So for instance, we know half America doesn't feel like going back to section 22 in the back of the library. So
I would think if that were brought to a librarian's attention, they would correctly catalog and shelve the material. And as you point out, I don't know about you, but when I'm in a library and I finish a book, I don't generally reshelve it. And candidly, the librarians prefer that I not do that. They prefer that I return it to a return area, and they professionally put it where it should be.
okay, so my final question, I think it's my final. Okay, so even when it comes to checkout, because I feel like there's too many points in this process for error. So fast forward to the end when you there's a lot of people trying to check out a variety of books, and you mentioned these electronic systems, and I'm assuming the electronic systems, of course, are going to be more so in this digital age, and a lot of the books that
Perhaps.
students are referenced or they are asked to read are ones that predate some of these things. So my question is, when it comes to you fully relying on the electronic systems, do the electronic systems currently account for all books that were cataloged or printed post the digital age?
Post-digital age.
Yes, so after this electronic system was created, all books that were prior to
Prior
that,
to that.
are they currently cataloged?
In most cases, yes. Now again, what is most cases? If you look at a service like EBSCOhost, they pretty much catalog all current printed material, and it's categorized. And at the end of the day, if I'm a minor and I take material to check out with a librarian or even in an automated system, the burden is on the individual to be of an adult age, or it's on the burden of the librarian to determine that you're a minor. We do the same thing with many products. So I have a store clerk determine, and I'll photo ID, alcohol purchases or tobacco purchases or any other harmful material that we feel minors should not have direct access to.
So they have to provide their library card and their
Well,
identification.
the library card
now?
is going to likely determine the categories of access they have.
Okay, so I just see a number of issues, even when it comes to either the criminal procedure aspect, and then just there's so many issues related to just the process in general. I understand what you're trying to do, the overarching goal, but there is, I think, a legitimate process when it comes to the code that we need to address.
I think that my experience with librarians and working with them for decades, they have a very keen sense of responsibility, and they will find an appropriate mechanism to comply with this limited change. And I would suggest that the vast majority already are complying. This does increase their awareness and allows them the opportunity to correctly catalog and shelve and make certain materials restricted.
Thank you.
Okay. So, a lot of ladies in my family used to read Diane Steele novels.
Daniel Steele, yeah. How old were they when they were reading Daniel Steele?
And I think one of my great granddaddy's brothers and my granddaddy used to venture and read a few of them too. I couldn't tell you what any of those are about.
I'm sure you couldn't. Nor could I, sir.
But I mean, this would prevent those books from.
My guess is that Miss Steele's writing would be inappropriate for a 12-year-old.
Oh, yeah.
Now, but again, if the grandparent chose to suggest reading to a grandchild, and the parent was acceptable, I accept that. I will acknowledge the fact that I had a neighbor who she was an elderly neighbor, and I would go shopping for her at the local Piggly Wiggly store, if you know where that is, and I had to pick up the National Enquirer for her, and I had to pick up Globe for her. It was embarrassing for me to purchase those materials for my elderly neighbor. But, that was her request, and I honored her request.
Good neighbor. Number 14, Chairman Gunner.
Thank you, Mr. Chairman. Okay, thinking back on my situation, I'm just trying to see how this might play out. There was a board over that library, and they're the ones that made the decision about this particular book. So who gets charged, the board or the individual that works in the library?
Very good question. I would suggest that the librarian would make a good faith effort, and part of that good faith effort is to go to the board and seek guidance. And before that person was charged, they would attempt to remedy that situation. And the only criminal accusation would be if they knowingly violated this statute.
So your line in there about has made a good faith attempt to identify and remove.
Yep.
That
That's not
would
remove.
include-
What does it say? Remove from?
Access to
Access. Remember, we're not banning any material.
Right.
We're not removing any material from the library. We're limiting access to harmful material.
Okay. So that would get them off the hook. And
Absolutely.
Then you go after the board if you're a
Well,
DA.
again, now the board would have to make a good faith effort.
Okay.
Okay.
Okay, I'm concerned about that.
Okay.
Thank you.
All right. I'll come back, I promise.
Promise.
We got a lot of people signed up to talk, so I did a little math. Which is scary.
Are you good at it, Mr.
Well,
Chairman?
there's a reason I went to law school, Senator. So what I'm going to do is, if you want to just scoot over
Sure, I'll
there,
scoot over.
I'm going to give each witness 2 minutes each. There's about 15 of you signed up. And so you get 2 minutes each. That's 30 minutes. We got a hard stop at 11 o'clock today. So I'll get through as many of you as, that I can. If you want to take less than 2 minutes, that's okay too. That is allowed. So I'll bring up Miss Brenda Heidman. Did I pronounce it right?
Yes, you did.
Thank God. Thank you. Come on up. Tell us who you with. Just a citizen, I say.
I'm sorry?
Yeah, I saw you. You're just here as a concerned citizen.
Yes.
Okay, good.
Yes.
Go ahead.
Okay. Brenda Heidman, thank you for letting me speak. This is code 16-12-103, enacted to protect children from sex, porn, and obscene descriptions and pictures of such, especially in public places. This is code 16-12-104 and makes all libraries in the state of Georgia an exception to this law, 16-12-103. In here, individual librarians are not mentioned. The institution of a library, the library system, is what they're talking about. So no one is going after a librarian unless by some extraneous behavior the librarian does something wrong. But this code is for the library institution that Senate bill wants to remove the exception for. Nobody's chasing the librarian. Children, knowing that children are in school libraries, knowing that during weekends, school breaks, and summer vacation, children go to public libraries, this exemption allows libraries to put porn, smut, obscene materials, and pictures and sex stories directly where children are sure to find them. And that's not made up. That has happened. Parents have pulled books off the shelf and found pictures of humans, adult human, genitalia with the hair and everything for little children to look at because it's in the little children's section. This exception is a gateway for endangering children and nullifies what Code 16-12-103 intends to protect. The exception is a legal path to breaking the law and criminal behavior. Please support this Senate Bill 74 and remove this exception for libraries.
Thank you very much. Appreciate you coming down today.
Thank you.
Priscilla Bentz. Good morning. Come on down. Another citizen. Thank y'all for taking time out of y'all's day to be with us. We appreciate y'all being engaged with us here. That's what we need more of.
Thank you, sir. Thank you, Chairman Smith. Good morning, committee. I'm glad to be here as a concerned citizen. My name is Priscilla Bentz. I did initially want to address two of you over here asked about internet, and I think Senator Burns answered that really well, but I wanted to also add that when children go into the library or if they go online on the internet, they've got to have their parents' card. So that's why that's not part of the bill. You know, you've got that safety valve already, not only the filters that Senator Burns talked about, but also you got the fact that the adult has to have their card and give it to the child to go online to read these books. So that's not a problem. The problem is the books on the shelves that are readily available. And it's a pervasive problem because I've been studying this for 3 years, looking at all the counties. Like Senator Burns said, it's not most librarians, but there's enough in there to be of great concern to parents. And we've noticed this more since COVID. You know, we all became more aware since we're educating and doing things at home, you know, more than we did before. kids that are homeschooled, my 5 grandkids, they all go to the public library. So it's just the awareness has been heightened of where things are shelved. And I wanted to read something from one of the testimonies that was given by a fellow concerned parent, actually. And he writes, he's told us that there's a growing concern among parents all over the state we can't ignore. For at least 4 years, concerned citizens have raised the alarm at explicit and inappropriate material in libraries. We know from extensive research and expert opinion that exposure to explicit material can have lasting negative effects on children. The American Psychological Association and the American Academy of Pediatrics have both documented the psychological harm that children experience when exposed to sexualized or violent content at a young age. Studies show that children who encounter such material often develop distorted views of relationships, sex, and even their own self-worth. And I would add they doubt what gender they are. Additionally, early exposure can contribute to increased aggression, depression, and anxiety. The harm is real. A study in the National Center for Sexual Exploitation found that access to explicit material can lead to premature sexualization, increased vulnerability to abuse. This isn't just theoretical, it's a matter of child welfare.
Ms. Bence.
And have I gone to 2 minutes?
We've had our 2 minutes.
Oh, I'm so sorry.
No.
I wanted to read some of the horrible things in a book, but that's all right for next time. I think I sent everybody some of the quotes
Thank you.
from some of the books. Thank you,
Appreciate
sir.
that.
Appreciate it.
Thank you. Miss Rhonda Thomas. Good morning.
Good morning. I'm here representing several thousand parents in Georgia, and I thank you for having us and for addressing this bill. I also want to point out something that was brought up earlier about a 6th grade teacher. A 6th grade student, typically 11 to 12, is in the early stages of abstract thinking but still relies heavily on concrete experiences. A teacher as an adult has fully developed critical thinking skills, the ability to evaluate complex concepts, and the capacity for long-term strategic thinking. They have been trained in child development. So if they are knowingly doing something, then we probably need to do some continued ed classes for these librarians, because they've already been taught child development and where these children are in their development. So I want to thank you, and I want us to express my support for 74. I also want to talk about the exposure to explicit or pornographic materials in young children can indirectly affect their pineal gland, primarily through disrupting normal sleep and hormone regulation. That gland is responsible for producing melatonin, a hormone critical for regulating sleep-wake cycles and contributing to a healthy brain development. Exposure to pornography can overstimulate a child's developing brain, potentially leading to increased stress, anxiety, and disrupted sleep patterns. And we're seeing high anxiety in our schools, so this is contributing to that. Chronic exposure and resulting stress can impair the melatonin production. Though direct studies specifically connecting pornography exposure to this gland impairment are limited, extensive research confirms that stress, anxiety, and disrupted sleep outcomes associated with early exposure to explicit content. We hear many times that it's not the books, it's the cell phones. Well, cell phones do present significant challenges for children. However, cell phones being a problem doesn't mean sexually explicit materials in our schools are not a serious issue. And I would say that I want to thank Senator Burns for putting children above adults. And I know that this law will protect the librarians as much as it will the children. Thank you.
Thank you, Ms. Thomas. Jill McCoy.
Good morning, Chairman Smith and committee representatives. My name is Jill McCoy. I spent 28 years in the Army.
Thank you for your service.
I'm a concerned citizen and a grandparent, and we were taught in the Army, put the bottom line up front. We want your support for Senate Bill 74. This needs to happen. As adults, it's our responsibility to care and protect our children. Parents need to know that their children's libraries are safe. and that when they come into the library and they go to their section and they sit on the floor and they start pulling books out to see which ones they want to take home, that they're not seeing stuff that's going to give them nightmares. And once they see it, they can't unsee it. And that's a fact. This is not a Democrat or a Republican issue. And it doesn't matter your race or your religion. This is an issue of protecting a child's mental and emotional health and protecting their innocence from scenes that make adults uncomfortable to read or look at. It's just, in my opinion, common sense decency. This needs to happen. And remember, once you see it, you can't unsee it. And if you've ever seen a horror movie when you were young, I did, and I still have flashbacks and dreams about worrying about whether Jack the Ripper was going to get me. Okay? So, thank you for listening, and we need your vote on this, and we need the support. Thank you.
Thank you. It's always good to see a real McCoy, too, if I might add. All right, Angie Walker. Good morning.
Everyone looks so great. Next time I'm going to bring my dress, so excuse the way I look. Thank you for this opportunity to speak. So my name's Angie Walker, and I'm here as a concerned citizen, and it was very last minute. But I'm also a licensed clinical social worker, so in July, 20 years with my license. So what I did want to just highlight what everyone said about, you know, children, the brain formation, and all the statistics you've heard. It is real. And then I remember, like, majority of my social work, since I'm a clinical social worker, has been in the addictions field, and my last job was at Fort Eisenhower in the substance use disorder clinical care. And what we see, all of in 2008, when I went to a addictions conference, they said in 20 years, our field is not going to be ready for sex addiction. But they were wrong, because it took less than 20 years. We're seeing it now. And even when these children are experiencing at a very young age this what they say the obscenity is, it's very specific. Unlike some of the newspaper articles, it's not subjective, it's very specific what obscenity is. It's defined in Georgia code, and it's not vague. But I just wanted to say, you know, please support Senate Bill 74, that we do need to protect our children. And we're not saying to remove it from the library. Again, it's moved to the adult section. So parents and grandparents, or whoever the caregivers are, they have the right to determine what is appropriate for their children. And I think that there should be a safe place. If it's a children's library, because many of us growing up, our parents didn't hover over us. I walked to the library by myself, and there were inappropriate stuff, like, you know, like when I was 11, 12, I think I ran into Harlequins. Those things are addictive, but that's not what we're talking about. You know, that's like nothing compared to what we've been hearing at the school boards and everything. But, you know, please support the Senate bill, and I guess my time's up, right? That's the 2 minutes?
Ma'am.
Okay, thank you for your time.
Hey, thank you for being here, Miss Walker.
Oh, thank you.
All right. Karen Parham. Good morning. Come on down. Morning.
Hi, good morning. Thank you for giving me the opportunity to speak today. My name is Karen Parham. I'm a resident of Columbia County. I'm not a lawyer, and I'm not a librarian. I'm just a mom, a veteran, and the spouse of a retired veteran who has found myself actively advocating not only for my community's freedom to read at my local public libraries, but also advocating for our local librarians who have really been bullied and treated badly these past few years. When I look at this legislation, you know, harmful to minors, it can be construed in different ways, right? So what we're seeing in our local community is some people have a certain definition of obscenity, and they want to apply that more broadly. And it doesn't necessarily meet the legal definition of obscenity. So we're looking at moving popular books such as The Fault in Our Stars. That's a book that was wanted to be moved to the adult section. We had a very lengthy discussion about penguins who raised an egg, male penguins. That was another book that was wanted to be moved. So how is this even going to be defined? And are we going to jail librarians for a book that is in the library but is readily available at Target? Because that seems to be what is being advocated for in our local community. They want to move these books to the adult section, but if you're saying it's a harmful to minor, well, doesn't that apply to Target? Doesn't that apply to Barnes and Noble? But it doesn't seem to be that is where that is being advocated for. So, you know, all of our library systems have a reconsideration process, some way to challenge a book. And so the thing is many of these individuals in our community have been challenging these books, and they're just not getting the result that they want. So they're hoping to pass this legislation so they can use the power of law enforcement in order to censor the materials at the library and make it how they want it. So I know my time's up. So
You're good.
thank you very much.
Appreciate y'all's service. Hold on, we got a question from Chairman Crow.
To that point, you said that they're wanting to use the law to censor this material, right?
Yes.
But if this material didn't violate the law, they wouldn't be able to do that because we're not changing the law.
Right, I understand that, but they're using the threat of it. So they're going to, for example, to my county commissioners. I had a very lengthy discussion with my county commissioners last night, and they point blank said that they wanted to apply this to the local library. And I said, well, what about Target? The DA can't just arrest the librarian. They'd have to, you know, if this book is considered harmful to minors, and that book is also available in Target, it has to apply in both places. And they said, well, we don't control Target. And I said, well, the DA, I mean, you can't just sell alcohol everywhere. So I have serious questions with how this is going to be applied. It seems to be that we have a section of our community that just wants to apply it at the library. And really, you would have to apply it everywhere.
It's already applied everywhere, though. I mean,
right,
this statute already applies. This statute already applies everywhere except the library. And there are people who are taking advantage of the fact, not all people, not even most people, but there are some people that are taking advantage of the fact that there is this exception to not have this law apply. And this is just, in my opinion, is providing, it's making it to where it applies equally to all of those places. And the carve out, knowingly, if you knowingly violate it, that means you intentionally did it. You had to know what you were doing.
My
and
point
that's
on
a big
this
addition
is
to that.
all of the books that are in the library are available at Barnes and Noble. My 14-year-old could get in the car with my oldest daughter, and they could go there and he could buy any book he wants, right? Those same books are available at the library.
Right. And at Barnes and Nobles, are they in the adult section?
Right. I mean, there's nothing stopping him from going to the adult section. It's wide open. If you walk into a Barnes and Noble, there's young adults and then there's adults.
Right.
So
and how would that be different? How would that be different in the library?
I think that would be different because what we're trying to do is shelve the library in a different way. You're trying to
Would
curate
they not be in the adult section in the library? That's where they should be, right? And if they're in the adult section in the library, that wouldn't be a problem then,
what
right?
I'm stating is
I'm not done.
Okay.
If they're in the adult section in the library, that's what we're trying to get them to have them in a place where they are not intentionally and knowingly being provided or given access to children, right? And that's where they are in Barnes and Noble. So I'm failing to see the difference in your analogy.
So the difference is, and I'm sorry I cut you off earlier. I apologize. The difference is that we have individuals who claim that certain books belong in the adult section, but they wouldn't be in the adult section at Barnes and Noble. So I'm trying to think, like a picture book, such as Tio's Tutu. That was recently a challenged book where a little boy wears a tutu. And they wanted that book moved to the adult section because they said that it's harmful to minors. So my question is, if this individual claims that it's harmful to minors, is the library going to be compelled just to move the book to adult in order to acquiesce to this, just to not have any perception or to not have the accusation.
Does that book violate Code Section 1612-103?
Well, I don't believe it does.
Okay.
But I'm not a lawyer,
Then how would
and I'm
that
not
be?
the
Then
DA.
that wouldn't be a concern,
But there
right?
are other books that are more it would be more subjective, right? Such as maybe one excerpt in a young adult book. You know, maybe taken out of context, it could seem more sexual, but maybe it tells a larger story within the context of that book. So does that one excerpt make that obscene?
Thank you, Ms. Parham. Thank you for coming all this way this morning.
I've used up
It's all right.
2 minutes. I apologize.
We're going to move on to Sandra Bowers. Good morning.
Good morning. Hi, my name is Sandra Bowers. I too am from Columbia County. I too am a very concerned citizen. I used to work at the library. I don't have a library science degree, but I worked at the library 17 plus years. The majority of that as a full-time worker, the majority of that in the circ department, circulation department, a little bit of that, maybe 4 years in the children's department. Just so you know, one thing that was mentioned earlier is that no child can access digital books without their parents' library card. That's not true. Here in the state of Georgia, we want all our children to have library cards, so we give library cards to all our children. Now, a parent can deny the child access to digital things, but they have to do that. That's an option when you get a card. And then apps like Hulu, Hoopla, and Libby are books, online books, that if you have anybody who has a library card can access those books. So children have access to digital information. Also, but nobody can check out a book without a library card. If you're under the age of 18, you have to have your parents' permission to get a card. Your parent has to sign you up for that. You can't go in there at 16 and say, I need a library card. We say you have to come back with your parent. Once your parent has the card, you then can check out books. And so in our library, the rule is you have to be 12, or you have to be older than 12 to be in the library without a parent. So anybody under 12 should have a parent with them. And as a person who took my children to the library, and I went to the library with my father, I looked at what they were reading, and I decided whether they're going to read it or not. I decided I never thought it was pornography, but if you want to say pornography, I decided if it was harmful. I don't need you to tell me what is harmful. I will decide that for my child. We do have a reconsideration process. And books are brought up for that process, and we go through the process, and you can appeal that process. So if someone truly feels like a book is harmful, that is what they should be doing. The way it is now, if you pass this law, it is me that will get arrested, or I would have been, for checking out that book to the person, and I don't think that's right.
Thank you so much. Who else came from Columbia County? Anybody? What's your name? Oh, I've already called on you. I'm sorry. Has everybody that drove for 2.5 hours to get here, have y'all been heard so far? Thank y'all. I know that was an early wake up this morning, so thank y'all for being with us. All right, Kim Timms. Is that how you say it?
It is not. It's Kim Thames.
Thames.
In London, it would be Kim Timms.
See, that's why I went with the
When I was in
English.
London, we had to go with Timms.
I guess you. Go ahead.
Once, I've
Go
been
ahead.
there once. My name is Kimberly Thames. I am a retired school library and media specialist from Gwinnett County, and I don't have much time to explain it, but I want you to, all the questions a lot of you have been asking about the processing, we as librarians don't decide what goes on the shelves. We have a media committee that's established that represents everybody across the school system, our school, and they create the criteria. The criteria is a very high standard. There's not pornography allowed in the elementary schools or in any schools, in high schools, anywhere. But the standards are much higher than just what they don't include. They also include making sure we have quality, that things that support the curriculum. And I could take my whole 2 minutes telling you what's on the criteria. But what is disturbing about this particular law is that We have a robust and effective criteria already in place in Gwinnett, and Gwinnett's where I was, and Georgia Department of Education requires this of all schools in Gwinnett and Georgia. And this law would give librarians pause. Right now, there is a huge list of lots of books that are going around many states. They're asking people to censor these books because they're harmful to minors. And these books that are harmful to minors represent history of people in the Holocaust. It represents people, my people, I'm Native American, the people of color, the Civil Rights Movement. These books have been listed and banned from schools when they're just history. And they are like not the pretty white American history that we all want to hear. So I'm saying that what this law will do was it'll make media specialists and teachers be afraid. They'll pre-censor, they'll self-censor themselves. And afraid, because they're afraid they'll be accused of a high and aggravated misdemeanor if they have these books on here. So I just wanted to say all that first, just explain why I think that it's actually harmful to minors to not let them see their history, to not let them see themselves reflected in the books that they read. And that's one of the greatest things about the library system. I could send you all about the criteria if you want and how we do it.
Thank you. Feel
but
free.
I know I used my 2 minutes.
Feel free to send that to us.
I will send you the criteria information. Thank you so much. Appreciate
Thank you
it.
for being with us. All right. Miss Cindy Battles. Good morning. Come on back.
Good morning. Thank y'all so much for the time to speak on SB 74. I have had the opportunity through this as this bill moved through the Senate to talk to the sponsor, to talk to all of the sponsors, and I have so many concerns about this, but because I only have 2 minutes, I'm going to talk a little bit about the fact that the sponsor says that this bill has been passed in 33 other states, but the way that Georgia defines obscene, I'm wondering how those other 33 states define obscene, right? Because in Georgia, that comma does a lot. And that in Georgia, that comma makes me obscene if I'm walking down the street with my girlfriend. My aunt who is a retired magistrate judge, by the way, lives in Jones County, and she went to the Jones County Library and talked to them about this bill, and they were really scared of what it means. So she contacted her state senator, Senator Rick Williams, and said, I'm really concerned about this bill. The librarians are really concerned about this bill. He sent her 2 pictures and said, I do not believe these books belong in the children's section. The Color of Love and Piper Chin Sings were 2 of the books on that shelf. So are we going to move The Color of Love to the adult section? That's all I have.
Is that the book you sent?
Yes, sir. I can send the emails and the pictures. These are 2 of the books that were on the shelves that he said do not belong in the children's section.
And he specifically pointed out those 2 books.
These are the books that are in the pictures.
Okay.
Yes.
And he said those 2 books don't belong.
He didn't. The email was very short, sir. It says, I do not believe these books belong in the children's section, and it was 2 pictures. And when my aunt pushed back and said that she has a grandchild who is queer and they should be able to read books about themselves in the children's section, he responded, you are silly and shame on you.
Thank you, Miss Battles.
Thank you.
Jennifer Saunders.
Good morning, Chairman. Good morning, members of the committee. I am Jennifer Saunders. I am a 26-year educator here in Metro Atlanta, and I'm currently the Director of Library Media Services for one of our Metro Atlanta districts here. And I love my job. I love helping to inspire a joy of reading in all of my students. And the reality is everybody likes to read something different. So I just want to give you a little bit of insight into how books are selected for our Library Media Center. We just, as was mentioned before, we have a selection process. Books are recommended selected by students first. That's what we first take into account. What do they want to read? And they tell us what they want to read. And then we listen to our teachers. What do you need to help your students become successful readers? And then we look at the standards. What books do we add to our collection that supports the standards? And those are the books that we put on our shelves. This particular bill raises some questions for me. It raises questions about what does good faith effort look like? And what about opposing viewpoints? We get that a lot with our high schools, and our media specialists are asking, we need books that have the opposite stance so that our students, as they are learning, can help develop their arguments. They can help develop their outlook on life. And when you think about our debate teams, they need to know those opposing viewpoints. Some other questions that arise is who is allowed to bring allegations against our libraries, and who investigates our librarians, and who provides the legal fees. There's just a lot of unanswered questions surrounding this bill, and it also creates an unnecessary fear in a lot of our library media specialists. So I'm going to ask you to not advance this bill, rather seek additional input from librarians around the state, and certainly from parents and from other educators before making a final decision. Thank you.
Thank you. Michaela Arciaga.
Good morning, y'all. Hello again. My name is Michaela Arciaga. I introduced myself to some of you yesterday, representing IDRA. I'm here this morning also representing a statewide coalition around education justice. We represent members of the education community from around the state, including many school librarians. I'm here to share some of their concerns, again, kind of echoing the concerns around the process. You heard from Ms. Thames that there are a wide variety of books that are being circulated around the state and the country. Our concern is, how will that be handled, again, by law enforcement, by our DAs? Does every single book constitute an individual charge? Does it constitute an individual challenge? If one person brings a challenge against a book and then another person brings the same challenges, how is that handled within our legal system? Ms. Saunders brought up the issue of legal charges. Many of our librarians, both public and school, are state or county employees. If they are charged in the line of their work, who is responsible for those fees, especially if those allegations are found to be unfounded? I also appreciated Chairman Burns that we've met several times about this bill. I've met with some of you about it as well. I appreciate the work being done by some of our colleagues in South Dakota. I do want to highlight that that body did vote on an amendment to remove criminalization from their library bill about 2 weeks ago. So if we are looking to them for an example, I think we should follow them and remove this section as well. I'd also like to highlight, we talked about Oklahoma. Oklahoma has several significant pending litigation cases going on, not specifically about librarians, but also around freedom of access to information, and also violating First Amendment rights as it pertains to education. And so I would encourage us to look to some of our more mindful neighbors, such as Arkansas, who have also chosen not to go this direction when it comes to moderating our librarians. We didn't get into as much of the process that our librarians go through to vet these books. I hope that some of you will reach out to your local councils. It is substantial because it is so subjective. Every book can be termed harmful to the right person. There are folks, you have folks from different parts of Columbia County that are here who are, some are saying this is harmful, some are saying it is not. It is not as easy as saying those things, which is why we have these councils to review these complaints and concerns around these bills. And every single library and school library has to have this process. Involving the criminal justice system raises a lot of concerns. And I worry that y'all are aware, and I know that y'all are aware of the burden this might place on the system in trying to navigate an additional level of complaints. So thank you so much.
Thank you. Sarah Hunt Blackwell.
Good morning, Chairman, members of the committee. My name is Sarah Hunt Blackwell. I'm the First Amendment policy advocate at the ACLU of Georgia, an organization dedicated to protecting Georgian civil rights. I'm here in opposition to SB 74, and there's a point of clarification that I'd like to offer as we've been having this discussion. Our criminal code differentiates between criminal mental states, distinguishing intentional and knowing. The mental state of knowing that is included in this bill is a lower threshold to meet than intentional, meaning that knowing and intentional are not interchangeable, and that SB 74 makes potential criminal charges against librarians easier. SB 74 not only threatens the constitutional right of free speech, but also imposes undue criminal liability on librarians, creating a chilling effect that undermines the very purpose of libraries as centers of learning and exploration. In 2024, a federal district court struck down nearly identical legislation in Arkansas, arguing that it violated the First and 14th Amendments. The ACLU of Arkansas and its partners brought suit against the law, and the court struck down key provisions of this law, underscoring that deputizing librarians as agents of censorship under the threat of jail time could create a chilling effect on the availability of literature in libraries. SB 74 creates the same legal vulnerabilities and will likely face similar constitutional challenges if passed. Under SB 74, librarians could face criminal charges for allowing access to materials that have not yet been banned through any official complaint process, but are still deemed illegally harmful to minors under state law. It is virtually impossible for librarians to read every book or every article that is available in physical copies or electronic databases. So how could we fairly and legitimately subject them to criminal charges for a factual impossibility? And without knowledge of an official challenge or complaint, it is dangerous and irreparably life-altering for librarians to be criminalized for content they may not even be aware of. I posit that this may have been a consideration for why the exception was codified in Georgia law in the first place.
Sarah, I hate to cut you off. But,
Yes, I understand, Chairman. Thank you for your time.
We're kind of at a hard stop. I've got less than 15 seconds till the hour, and we've got a prior commit. Brother Mike, Noel, and Miss Margaret, we'll take this back up, and I'll put y'all at the first of the list. Congressman Emeritus, I'll let you give a brief overview when we start back, if that's okay. We'll members look for another meeting potentially this week, if not by the end of the week, Monday. We're just trying to get everything scheduled in just right. So thank y'all for being with us today. Thank y'all for everybody that came. We appreciate y'all being engaged. Stay engaged with us. Thank you. We're adjourned.